All present in the Great Hall, please rise. The Court of Appeals is now in session. Please be seated.
Oh, no wheels.
I know. Good morning and welcome to the Court of Appeals today. We are honored to have oral arguments this morning in this beautiful space down here at Southern Utah University. I would like to take just a few seconds to acknowledge some people that have made this happen, and I wanted to thank. First of all, I am Judge Michelle Christensen Forrester. I am the presiding judge of the Utah Court of Appeals, and I am joined on this panel with my colleagues, Judge Dave Mortensen and Judge Gregory Orm. We have sort of made this a tradition that we love. It is so wonderful when the Court of Appeals can travel and interact with the community in other places. And I thank you, counsel, very much for, I know at least one of you made a drive down here, and I am very grateful that you could be here today as well. Please let me thank, before we begin, I'd like to thank Brian Paul, who has been our host, Lee Byers, who is doing the IT streaming for us, Kevin Jacobson, who is the chair of the Political Science and Criminal Justice Department, and Trooper Joshua Greenman. Thank you for all that you are doing. So for the Court of Appeals, when we hear arguments, obviously we sit in panels of 3. Both sides have 15 minutes in which to make their arguments. The appellant, who is seated on this side, can reserve some time for rebuttal. And it appears, based on the clock that I am looking at, that you have reserved 5 minutes for rebuttal?
That's correct, Your Honor.
Perfect. We will ask questions. The attorneys will present their argument. Do either of you have any questions about how these proceedings will go?
I guess my only question is you normally we might jump right into legal arguments. Do you want a summary of the case for our audience, or we know that you're already familiar with it? So.
They actually have been provided, and we may have some factual questions that might clarify some of our questions. So, but thank you for that.
But if all went well, they got a handout summarizing the cases. Did you all get a summary? Oh, look, I'm seeing them held up. Excellent.
So I think we can go right into oral argument, or right into the legal arguments, as that may be. I guess one thing I would like you to do before you begin your argument is if you could please enter your appearances for the record. We are streaming, the audio anyway. We are streaming, and so it's always nice to know who is speaking. And so then every time you do come to the podium, if you could reintroduce yourself and enter your appearance as well.
Okay.
You may begin.
Thank you, Your Honor. Brad Haar representing Doug Reath. We're recognizing that the court sent out a notice asking about Hale versus Beckstead and Section 343 and 343A. We didn't really address those in our briefs, primarily because for purposes of the summary judgment motion, which was filed, defendants conceded duty and breach. And so none of that analysis was done. So I have arguments, but I guess what I'm curious about is if there are specific questions or applications that you wanted me to address. Certainly we're ready to discuss those issues.
Well, I recognize that Hale is a duty case and that the restatements are describing the duty. But the briefing in this case cited a bunch of cases having to do with products liability. And to be sure, we're talking about tort and negligence in this case. But sometimes the particular duty that applies can have an effect on the analysis of other elements of a tort claim. And specifically in section 343, well, I guess we should back up because factually, I'd like to know whether you think duty-wise 343 and 343A apply.
Yes, they do. And very clearly so. I mean, this case involves Bryan Head Town, for purposes of this, I think qualifies as a public utility under 343A. As they are providing water to the community, our position is they have to do so in a non-negligent way and in a way which warns or instructs users in a way that would prevent foreseeable harm. It is our contention that what happened to Mr. Reath when he put the hose in his water storage tank and turned that on, that was a foreseeable incident. There was time spent in the depositions with Wendy Dowland, Chris Lay, Brett Hauser, and there's another gentleman from the maintenance department, asking them if they were aware that because of the high pressure nature of this bulk water dispenser, that the hose could fly and hurt someone. They were unaware. We were unable to discover anywhere any physical injuries to people they were aware of. However, there was an incident that Wendy Dowland was aware of where the hose had come out of the top of the tank in a very similar way and knocked the back of the glass out of a truck. At least that was what was reported to them.
What I was really getting at is the dispenser. This isn't some little portable water dispenser. It was installed by a company, I can't remember the name of them. Installed in 2011, I think, is what your brief said. And it's a fixture on land. Is that accurate?
That's accurate.
Okay. Now, I didn't see it in the briefing. Everybody has a code, and then they're able to take this water. I assume that they're charged money for the water.
That's correct. You would go in, Mr. Reath testified that's not disputed. You go into the city, you fill out an application, you give them a credit card, they give you a code, you punch your code in, you punch the number of gallons, you swipe your credit card, and then you...
So both the dispenser and the land that's sitting on are owned by Bryan Head Town.
That's correct.
All right. I think I understand the lay of the land there. The picture that we saw of the dispenser in the briefs was a partial picture. We didn't get a full picture of how it sits there, but it did look like something rather permanent. So anyway, going back to 343A, it says that a possessor of land is subject to liability for physical harm to his invitees by a condition on the land, and it has three different factors. And if that owner of land knows that in the exercise of reasonable care that the people would discover the condition and know that there's a risk, and I think you've briefed that well, but subsection B of 343 says that they should expect that they will not discover or realize the damage. Now in this case, or the danger, I'm sorry, in this case, Mr. Reath acknowledges that to some extent he knew that this was dangerous, and in fact, in his own words, knew that it could come with the force of a fire hose. But the last part of subsection B is what has caught my attention. It says it will fail to protect themselves against it. And so this restatement goes particularly to the issue of when people know that there's a danger, but the owner of the property knows that they might not respect the danger sufficiently. Then the duty arises to do something more warning-wise or otherwise to protect those people. It doesn't appear to me that the briefing really focuses necessarily on that. Obviously, there wasn't a discussion of 343. Do you think that changes the analysis in any way?
Well, I don't, so for purposes of the motion for summary judgment, counsel said we acknowledge that we didn't warn or instruct, and we acknowledge that breach, and we just don't care. Because in his misuse of the water dispenser and the 25 times that his code was punched in, he should have learned how dangerous this was, appreciated how dangerous it was, and because he knew how bad this thing was, and he encountered it anyway, that's his fault, and we
I don't
that brings the causation
necessarily,
chain.
I'm hogging all the time, but I don't think that's necessarily the argument they're making. I think they're saying that your claim is that they should have warned you, or your client, and then they ask the easy question, well, what would the warning have said? And you've outlined what the warning would have said, and then they say, well, your client has acknowledged in his deposition that he knew all of the things that you say he should have been warned about. So how can we be liable if a sign would have only informed him of information that he's already acknowledging he knew? I think that's what they're arguing. They can clarify it on their side.
Well, yeah, so our contention is there's two things. One, we argue that they didn't warn. They should have had a sign that said, high pressure hose, make sure the valve is shut off before you use it or danger could arise. That never happened. Mr. Reath acknowledges that he knew it was a high-pressure hose. He does not acknowledge that he had any idea there was sufficient pressure that would lift him up and throw him out of the back of a truck. The other thing that we argue, or that we think is important is, and this is where maybe our briefing got a little bit skewampus in mixing 402A, or the analysis of 402A and 343, is the Fiesel case, which is a products case. It was cited not for the duty portion, but for the idea that when you fail to warn, it becomes a question of fact for a jury to determine how the warning and the actions would have been. Had he been warned, had he acted differently? In this case, we argue, of course he would have. How do we know that? In fact, we know it would, because after the accident happened, a friend, he says a friend, we don't know how long it was after, he says, hey, why are you doing that? You have this nozzle on the bottom of your tank, that hose hooks up there, and then you turn it on. It's a one-person operation, rather than hoping somebody on top is strong enough to hold the hose in place while you turn it on, even if you fail to close the valve. There's two valves. There's the one valve that's operated automatically when you punch the code in, and then there's a WOG, or a wide open gate valve, like a garden hose variety. They were aware that gets left open and creates a hazard. Mr. Lay, in his deposition, says, yeah, I see people draping the hose over the tank, and I tell them, hey, hook it up, it's better. And importantly, one of the instructions that we think that goes to breach in the 343A and 343 and 343A is the manufacturer's instruction that were never provided to anyone. It could have been put in an email. When you go to get your code, it could be a sheet. The number one instruction, importantly, says, connect truck fill hose to the water truck. This is a commercial bulk system that's designed for commercial operators, not cabin users. We're not arguing the use is inappropriate, but the failure to instruct on how to properly use the bulk water system, that's a breach that goes to causation and to comparative fault, that's a jury determination, not a question of loss that should have been dismissed the case on summary judgment.
Well, that's why I think the court focused on causation. There was a breach. Well, there was a duty. The town acknowledged some negligence. We breached the duty. It's not what caused the injury here, however. What caused the injury was your client's failure to make sure that that faucet was clear off before punching in the code and hitting the start button, which had been his practice before. He knew that. He acknowledged occasionally, I forget, and it all seemed to work out on prior occasions, but he understood the important step of making sure the faucet is off, hit the start button, then turn it on slowly. And he didn't do that here, or ask his older friend to do that here. That's what caused his injury.
And that's why in oral argument, we were asked that question on the motion below. He said, what difference would a warning make? Well, if he's the guy that's in charge, that's normally in charge of and holding, and he is now in his abnormal position, this is his second or possibly third time being on the hose end. The person down that's going to hit the start button, he sees this sign that says high pressure hose, make sure the valve is turned off. That's a clear warning to anyone, not just on the end of the hose that's familiar with it, but somebody helping him, whether they're familiar or not. So in our position, this was a time bomb just waiting to happen to someone, whether it's Mr. Reath or someone else.
So just to clarify, because I'm not familiar with water dispenser systems, the warning should have been to close, to make sure that the
Faucet.
faucet was
The
closed,
valve.
not necessarily, here's how you hook up the, what Mr. Reath learned later about how to use the cages or whatever they are on the actual hookup.
Well, frankly, Your Honor, I think it's both. I think they had an obligation to put a sign that says, make sure the valve is turned off and make sure your hose is securely connected. It's our contention that you should never be filling your storage tank with a fire hose through the top of an opening of this tank or any other tank. They chose the manner of delivery of the water. They chose a fire hose system with a cam lock system. That is not within the normal realm of experience of most people, including me. I've never hooked one up until I came up with this. I say including me. I've done horses, I've done other things where I've used a lot of water dispensers, never hooked one up this way. So it's an abnormal use, and then we're expecting lay people that are not necessarily familiar. It's a fire hose. This is the same connection they use to a fire hydrant. And the other thing that's one of our other contentions that got overlooked in the underlying portion, it goes to your question, Judge Warm. One of our contentions is it should have had a pressure reducing valve to the extent that would not allow this to happen in the first place. Well, then a warning wouldn't be relevant because there would never be sufficient pressure to pick someone up and cause harm. I'd love to answer more questions. I already see I'm out of time. I'd like to reserve a little bit for rebuttal.
Well, I've read the transcript of the hearing and reviewed the order of the court. I don't see a lot of discussion about the pressure reducing valve.
We didn't get that part. The court came and said, well, what difference would it have made? But if we look at our complaint.
Well, but the pressure reducing valve has nothing to do with warning, right?
No, nothing to do with warning, but it goes to duty and breach. If you know you have something that you're putting an instrumentality out there that is going to cause harm, and it could be mitigated by a pressure reducing valve, which is something that we alleged in the first instance. The court never got to that because in our view, Judge Bell got sidelined on the fact that, well, he should have learned through his prior misuse how to misuse it safely again.
Misuse it safely.
Yes, yes. I'll reserve the rest of my time. Thank you.
Thank you, Mr. Hart.
Good morning, Your Honors. May it please the court, Gregory Houle on behalf of Appellee Brian Head Town. Before I launch into my argument, are there any questions I can answer for the court?
I did have one curiosity. Typically on motions for summary judgment, it's an axiom that courts don't find facts, that the fact finding should be left for a jury. In your order granting summary judgment that the court signed, it says that after being fully advised in the present premises, the court made findings of fact. That's what the order says. Did the court make findings of fact?
The court concluded that there were no disputed facts. That would be a more accurate and better way to phrase that.
And that happens all the time on summary judgment. Try as we might to offer various teaching moments, but we continue to see findings of fact, and we end up typically okay, the court called them findings of fact, but what they really are is a summary of the undisputed facts. The minute the court's about the business of weighing evidence and truly resolving the facts, we're not in summary judgment territory. But you don't contend that's what happens here. Mischaracterization.
That's exactly right, Judge Orm. It should have said the court found, or the court
Determined.
Determine the following undisputed facts. That would have been the better way to phrase it.
One other question. Is your position that the court implicitly ruled, because there's no express statement of anything about the pressure valve, that there should have been a pressure reducing valve like everyone in Utah usually has in their house, code requires it. Is it your position that the court implicitly held that that was irrelevant?
Absolutely. It was a necessary implication because regardless of whether, there was a pressure reducing valve or what the pressure was, Mr. Reath knew how to reduce that pressure to 0 before he activated the pump. So just as I begin, I want to just clarify a couple.
Before you leave that.
Please.
I'm thinking through that. If you had a pressure reducing valve on it, then the potentiality of the danger would also be reduced to 0 before anybody touched it, right?
That's exactly right. And there was, in fact, a pressure reducing valve. It was the faucet, the valve.
No, but if you had we're talking about pressure reducing valve like the one in your house. You can't, maybe you can, most people can't walk up and fiddle with their pressure reducing valve in their house without a wrench. I mean,
correct.
You got to really be thinking, I want to destroy all the fixtures in my bathroom now. So that's something that just stays in place. It's not messed with by the user typically. In fact, I would bet that half the people in this room, if they know where their pressure reducing valve is in their house, and they probably don't, they certainly don't know how to monkey with it. So
absolutely.
It's something that just stays in place and you don't. It's not like
correct.
the faucet on the side of your house.
That's right. And in this case, there were two. There was an internal pressure reducing valve, which a user doesn't have access to, as you're alluding. You need tools and a wrench and whatnot.
Why wasn't that at a lower pressure?
Well, again, our argument is it makes no difference because there was an external pressure reducing valve that Mr. Reath knew how to use.
And had used on many occasions.
Many occasions. And had seen other people using. All it required, we're talking about a garden hose bib. All it required is a few turns to turn it to 0, then hit the button. He knew that. He knew the consequences of not doing that.
But doesn't,
sorry, go ahead.
I was just going to say, doesn't that assume knowledge, right? Like,
No, Mr.
should
Reath
there
testified.
be a failure to warn? I mean, yes, he testified he knew about the faucet or the valve from the faucet, but that he had occasionally forgotten to make sure it was closed before utilizing the dispenser. Doesn't that assume knowledge from all users? Right? Like, if there's no warning, if there's no sign or no instruction that has been given previously, doesn't that just assume that the users will know that?
Judge Krushanson-Forster, I'm not exactly sure if I understand your question, but to be very clear, Mr. Reath's testimony was not that he sometimes forgot. His testimony was that he knew other people sometimes forgot. And despite that knowledge, because he wasn't as vigilant in his words as he should have been, would activate the dispenser anyway, knowing there was a risk, and hope that it wasn't turned on full blast. That was what Mr. Reath testified. So,
because the underlying issue is, I think, if I understand, that if you put in to your code or into the input the number of gallons of water that you want, when it reaches that, the prior user, it just turns it off. So the valve's wide open and now it's not running. And so the next user, if they haven't closed it, and if the next user doesn't verify that it's closed, then they're subject to this.
That's exactly right.
Pressure.
That's exactly right. Mr. Reath testified he knew that was the case. He knew that it was often the case that prior users would forget or neglect to turn down the valve. So just really briefly, I wanted just to clarify a couple of things. The Bryan Head does not concede there was know that there was a duty and that we breached the duty.
You said that in your motion.
We don't contest it. There's an important difference.
For the purposes
For the purposes of this motion.
Right.
We did warn Mr. Reath, but the extent of that warning is a matter of disputed fact. So for the purposes of this motion, we have just said, put that aside. Even if that's the case, there was no causation. Now, one other quick clarification regarding disputed facts. It was argued that this hose picked Mr. Reath up and threw him out of the truck. That's not accurate. If you look at the undisputed facts, including the video, it shows Mr. Reath standing precariously on the side of his truck and then trying to hold the hose with one hand, losing his balance and falling out. He didn't get picked up by the hose. I think that's kind of an important fact because we're talking about the extent of the danger that exists. And that gets back to Hill. And to answer the court's question, yes, I agree. That case squarely applies. I think it's an alternative basis of affirmance in this case because if you look at Hill, which is defining the duty, and it basically requires three things. It's saying under the modified known and obvious rule standard that a landowner is not liable except in three situations. One is where the invitee didn't know the danger, was unaware of the danger. Two, was aware of the danger but may forget about the danger. And three, whether if the invitee might not have an alternative way to get around the danger. I don't think that's the exact
But
wording.
he's clearly, he's a business invitee, right?
We don't dispute that. We don't dispute that. And the third, just to use the actual language, is where he may reasonably encounter the danger despite the obviousness of the danger. And that gets to the public utility issue. It's similar to an employee. An employee doesn't have to choose between facing a danger and going to work. An invitee using a public utility has the right to use that utility without exposing oneself to danger. So the critical fact here is whether or not there was a reasonable alternative. So we think about the staircase that the Hill Court relied on that had just been waxed and was slippery, and the employee had no other alternative but to try to navigate those stairs or else not go to work, which the court concluded was that's not a reasonable alternative. Here, there was a reasonable alternative. There was a known danger. We know this because Mr. Reath warned his friend, hey, when I hit this button, this thing's going to take off. Be careful. Watch yourself. So he knew of the danger. And of course, we know he didn't forget about the danger because he warned his friend of the danger. He knew exactly what was going to happen, what was likely to happen when he hit that button. But he simply chose to assume that risk. And then the third thing is...
Assume it by not making sure the valve was in the off position or ask his friend to do so before.
And that's exactly right. This would have been a 3-second task that for whatever reason, Mr. Reath just decided not to do, as he had done on occasion before, even though he knew he should be more vigilant. He knew of the risk. He assumed the risk. And to the third factor under the known and obvious rule...
Assumption of the risk is a matter of law, you're arguing.
Absolutely.
On these facts.
When the facts are undisputed. Absolutely. And so Mr. Reath just took that on. He had a reasonable alternative. This wasn't a staircase that had to be navigated. This wasn't railroad tracks encumbered by luggage that he had to navigate. There was a way around the luggage. There was a way around the staircase, and that was simply taking 3 seconds to turn down the valve.
You've just mentioned assumption of the risk, and for many years here in Utah, if a plaintiff had been found to have assumed a risk, then they were just out. And then we had the comparative negligence laws
Correct.
enacted, and I think it's pretty much black letter law now in Utah that with assumption of the risk that can provide for an assumption or a
Weighs into the comparative analysis.
The comparative analysis to the plaintiff. However, comparing that negligence still goes to the jury, doesn't it?
It does when there are disputed facts. Where the facts are beyond dispute and where no reasonable jury could conclude otherwise, I think it is appropriate for a court to determine, just as causation is. We know that causation is typically a jury question, but there's an arm's length of cases where causation was determined as a matter of law because the facts were so clear, so undisputed, and that no reasonable juror could conclude otherwise. Right. That's really the critical factor, and that's what distinguishes this case, by the way, from the factual dilemma of the Hill case, because in Hill, it was unknown whether or not the painter had to expose himself unreasonably to the open balcony. Those facts just were not elucidated in the case. And so the court couldn't make the determination whether or not there was a reasonable alternative available to him. In contrast, in this case, we know exactly what the alternative was. We knew that Mr. Reath knew, we know that Mr. Reath knew he could turn down the valve. That was the reasonable alternative. In Hill, that was unknown, so they determined summary judgment was inappropriate. Here, it's not an unknown. The facts are undisputed, and that's why summary judgment was appropriate with respect to causation. Again, before we even get to causation, I agree with the court. There is a duty question, and I would argue that under the three-factor analysis of the known and obvious rule, there is no duty in this case because Mr. Reath knew, and because he remembered, and because he had a reasonable alternative. In other words, he didn't reasonably expose himself to the risk because there was an alternative. Just real quickly to address this idea that the city had a duty to teach Mr. Reath how to use his own equipment, I would submit there is no such duty. To argue such would be to say that the DMV has a responsibility to make sure you know how to drive your car after it issues you a driver license. That is simply not the case. And what happens when you buy a new car? What if you buy a used Jeep CJ5 that has a finicky clutch? Is the DMV to come to your home and make sure you know how to use it before you pull out of your driveway? Absolutely not. The government has no such role. Mr. Reath and Mr. Reath alone was responsible to know how to use his own equipment. But to be clear, there are two things that had to happen here for this accident to occur. One is he had to leave the valve open, and two, he had to improperly connect the hose to his tank. Had he done either one of those, this accident never would have happened. That's why there can be no causation, because Mr. Reath knew how to avoid it. He argues there should have been a $5 sign that said, "Warning, high pressure, turn down the valve." He already knew it. He knew it. Had he done just that one thing, there would never have been an accident. And that's why there's no causal link in this case. And that's why the district court ruled the way it ruled. And that's why I would submit this court should affirm the district court's ruling. Unless there are any other questions, I will submit it on that.
There's even a little time left.
20 whole seconds.
That's the first time that's ever happened to me. Thank you, Your Honors.
Thank you, Mr. Hool. Mr. Haar?
Well, shockingly, I disagree. So first, let's go to the use your own equipment idea. The tank didn't hurt him. The tank didn't move, the tank didn't shift, the tank didn't push him out of the back of his truck. He was hanging onto a high pressure hose that when it hit, whether it lifted him up and threw him over the side, knocked him off. I'm not suggesting it threw him up in the air, but it's clearly the pressure in the hose that, when it was activated, turned it off and pushed him to the ground.
You concede that a jury looking at this case reasonably could find that the overwhelming amount of negligence is on Mr. Reath and that he shouldn't recover. But your position is a jury should make that decision and not a judge. Is that right?
Well, I disagree that a jury will find that, but I do think
I didn't say will. I said might.
I agree that a jury could find it equal or could weigh in the city's favor. This is not a rear-ender at a stoplight, or even though I'm aware Judge Mortensen's already has won one of those. But generally speaking, it's not that case. We acknowledge that. But did he unreasonably act? Well, okay, let's say he did, and he bears some responsibility. That's where the duty analysis comes in. In paragraph 30 in Hale, it says the law simply requires owners to take reasonable steps to protect invitees. The duty does not require the landowner fully remedy potential unsafe conditions, only that the landowners adequately warn invitees of such dangers. I think we've gotten a little bit sideways in terms of warning and instructions. We're arguing there's a duty for both. The warning is high pressure hose, make sure the valve's closed. But there's also a separate obligation that we argue is a duty to instruct. The instructions are, and this is where the FISL comes in, is the town was given an operating instruction for the bulk water system. That is found at page, in the record, eyes weren't what they once were, at record page 348. The number one instruction that was never passed on to him was connect the truck fill hose to the water truck. In this, it's not a truck, it's a tank. But if he never knew, he was never instructed, he had never seen it done, he was never, when he got his account, what he was told was some version of be safe. Elsewhere in our brief, we provided and cited the internal memo from Aldo Biasi to Wendy Dowland saying, make sure you instruct them, and it's in big letters in the exhibit, to make sure the valve is turned off before they operate the system. Well, that goes back to your question in Hale, where what Hale said, the third prong is not, sorry, it talks about whether they'll forget about, whether they'll count, and then what it actually says is fail to protect or will fail to protect themselves against it. If that's foreseeable, then they have an obligation to warn and instruct. That's what should be weighed, and be weighed by a jury, not dismissed as a matter of law.
And I guess that was my question. That is what I was trying to get at in my prior question, is that, and it's not just an assumption here, because Mr. Reath testified that he did know that, but he did know that to make it completely safe, the water pressure should be, the valve should be turned off at the source, right?
He knew that would be prudent. Yeah, there's no question he testified that would be prudent. But there's no evidence, there's no testimony in there from Mr. Reath or otherwise that he recognized that the hose was so powerful that it could push him out of the truck. In the depositions from Brian Head's employees, they say the pressure at the bulk water dispenser is the same pressure at a fire hose. Well, that wasn't ever told him. There were examples where they shared that to other users, but he was not aware of that, nor was that ever told to him. He was just aware it's a high pressure hose.
Didn't he tell his friend that it was a fire hose? Am I misremembering that?
I think he did say that in response to, in his depositions, he paraphrased something to that effect.
He said, watch out, this is basically a fire hose.
It's like a fire hose.
Right.
Does that mean, so that assumes that a public utility can say, all right, well, here's the fire hydrant, here's the key, turn it on, go for it. And as long as you've used it a few times, here's where the difference comes. We're getting, in this particular case, yes, a jury, I don't get an automatic pass if we get a shot at it. There's gonna be a comparative analysis. But if this was his, would we be having a different conversation if this was the first time he used it? And the answer is, of course we would, because there would be no, so our argument is that Bryan Head Town has an obligation to protect against known users. Well, who are the known users? There are cabin owners everywhere. It's Mr. Reath specifically in this case, but it's people like Mr. Reath. This could have happened to anyone. It could have happened to a first-time user. So because he's not a first-time user and he didn't learn how to misuse it right, or he didn't appreciate how to misuse it right, our contention is the negligence started when the duty was breached, when they weren't given the instruction and said, hey, you only use a C-clamp on this. You make sure the hose is connected. And then the rest of this is irrelevant because the hose is connected and it can't go anywhere. That's what we think we should be able to present, that theory of the case, to a jury.
I have one final question. Mr. Hu, I think, told us that there is two valves actually in the dispenser. There's basically a water spigot on the outside. That's the valve, the wad that you talked about. Is there a pressure reducing valve on the inside?
Go ahead. Well, there's two ball valves on the inside. We didn't get into this too much in the oral argument, but there's two. It's basically a manual valve. And when the water, it did not become an issue because we can't show that municipal systems ever showed this to Brian Head. There is an internal memo from municipal corporation that said, hey, we were told to make sure this has 50 to 100 PSI was what it was going to be, and it's at 170 PSI. So we turned the pressure back. Please pass that on. We can't show that was ever passed on to Brian Head Town, so we're not relying on that. But what did come out in the testimony is the way the water system works, it's a gravity fed system. So they have a tank higher up, and they say, so what's the pressure at any given time? Well, we don't know. It depends on how many users there are, how full the tank is. So the pressure will fluctuate from use to use and individual to individual. So even if he had knowledge, we have no idea with other prior times if the pressure was half what it was the day in question, which is where the pressure reducing valve argument comes in, but also the instructions of connect the tank and warning, don't care what it's like, make sure this is turned off.
Just to be clear, so the installers throttled back the pressure to the range that Brian Head had requested?
Correct.
All right.
But again, to be fair to them, we can't show that was passed on effectively to anyone that remembers back in
What wasn't
2011.
passed on? The fact that they reduced it, or the fact that they could reduce it further?
The fact that they reduced it.
Okay.
Yep. Thank you.
Thank you. Thank you, counsel, for your arguments today. We will take this matter under advisement and render a written decision as soon as we are able. Appreciate your helpful arguments, and thanks again for coming. We will be in recess for
Till 11:30.
till 11:30. I'm not used to.
This court is now in recess until